Proceedings resume on the Comicsgate trademark as Ethan Van Sciver joins the trial. But is it too late to save Critias's mark? Hello, this is Robert Romano with Comicsgate.org. Hit that subscribe button. Today we're going to be talking about the Comicsgate trademark again. The trial has now resumed as of July 6, 2021, according to the Trademark and Trial Appeal Board. Quote, since the filing of Common Sense Press Incorporated's petitioner's petition, that's Preston Poulter, on October 1, 2020 to cancel registration number 6102744. This is Antonia Malpica's trademark that was fully registered on July 14, 2020. Quote, numerous papers have been filed by Antonia J. Malpica without the benefit of an attorney, including a putative answer to the petition for cancellation and counterclaim, as well as a motion to compel and motion to dismiss. This matter comes up on petitioner's motion for judgment on the pleadings and in the alternative motion to strike the answer and counterclaim. The motion has been fully briefed. According to this, quote, of an action before a court for which the lawyers on both sides have presented all the arguments which they are permitted to present and for which nothing further remains but the ruling of the court. So basically, what USPTO is saying here is that all of the papers have been put into place, all of the filings by Antonio, Critias, and Preston Poulter's attorney via Common Sense Press Incorporated, that there are not going to be any more arguments on these motions. They're going to rule on these motions. Malpica's findings preliminary. It is incumbent upon the board to note various defects in Malpica's filings. First, each of the filings appears to consist of a confidential version of the filing, as well as a redacted version, also designated as confidential. This is improper. The official record of a board proceeding is to be made available for public inspection and copying. So Antonio didn't do his job here. He was supposed to put this into a public Dropbox. He filed them confidentially. He didn't need to do that. To the extent confidential materials are to be filed with the board, they appear to be submitted under separate cover, clearly identifying that the material is confidential, with an appropriately redacted public version concurrently but separately filed. Mr. Malpica failed to do so. As a result, the redacted version of each file was shielded from public viewing, contravention of Rule 2.27d. To remedy the matter, the redacted version of each file has been separately entered into the preceding file and are made available for public viewing. The extent that petitioner has confirmed receipt of the papers by way of email dated December 10, 2020, and in view of the board's entry of the redacted version of each filing, the board sees no need to forward the filings to petitioner. Notwithstanding, Mr. Malpica is advised to take care that he comply with the board's service requirements as set forth in trademark rules in all future papers filed with the board. So here, the board, I think, is granting mercy to Critias and saying, look, we know you didn't have an attorney. It's okay. We've got everything in order now. Here's all your claims. Here's all the counterclaims. Finally, since the board deems a proceeding suspended as of the filing of a potentially dispositive motion concerning all matters not germane thereto, Mr. Malpica's motions to compel and dismiss will be given no consideration as they were filed during the pendency of petitioner's motion for judgment on the pleadings and are not germane thereto. So, now on the motion for judgment and on the pleadings and the motion to strike, turning to petitioner's motion for judgment on the pleadings, it is denied as the motion is based on a submission that the board does not construe as a proper pleading. That means that Preston's motion to for judgment on pleadings has been denied. Mr. Malpica's submission as of November 9 is less a cognizable answer to the petition than it is merely argument more appropriate to a brief on the case. The filing is therefore unacceptable as a responsive pleading upon which a motion of judgment on the pleadings may lie. Indeed, petitioner appears to recognize the insufficiency of the filing and alternatively moving to strike the submission based on Mr. Malpica's failure to, quote, admit or deny the allegations, or to otherwise, quote, respond properly to petitioner's allegations. Thus, the motion to strike is well taken and hereby granted. So the motion for pleadings, a judgment, that's denied, but the motion to strike has been granted. Striking answer found to be verbose, argumentative, or redundant, and in gross violation of Rule 8, Mr. Malpica's submission of November 9 is stricken. And so that was a motion put forth by Critias on November 8th, and then they receive it on November 9. this whole thing, this whole response that he did, that goes the way of the dodo. It's not going to count. They're not even going to consider it. That's bad news for Critias. Mr. Malpica's submission of November 9 is stricken, and his motions to compel discovery as well as to dismiss based upon standing were outside of the time frame that was permitted under the law to put forth such filings. Now you have the motion to join an appearance of counsel. As a final matter, Scott Houtteman of Houtteman Law, LLC, filed notice on April 15, 2021 of an assignment of the involved registration to Ethan Van Sciver on April 14, 2021, and moved to join Mr. Sciver as a party defendant in this matter. As the assignment occurred after the commencement of this proceeding, and as petitioner has not raised any objection thereto, the motion to join is granted. Since Mr. Sciver, I should say Mr. Van Sciver, is the assignee and party in interest in this matter, the correspondence information for Mr. Van Sciver and Mr. Malpica, collectively respondents, has been updated to reflect Mr. Houtteman as the primary correspondent for respondents. As issue has yet to be joined in this matter, respondents are allowed until August 2, 2021 to answer the petition for cancellation or to otherwise move in regard thereto. Proceedings are resumed in accordance with the following schedule. Now there's a new trial schedule. This is probably pretty good news for Ethan insofar as there could have been just a default motion in favor of Preston and the cancellation of Critias's mark. Here, the USPTO is saying that we're going to start over. We have a real attorney present now. Ethan's on the case now as well. Ethan has his own trademark for Comicsgate that he's put forth, and I think that it's probable that this could be going on for quite some time. August 2, time to answer, deadline for discovery conference, September 1. This is terrible news for Preston. This is going to drag on and on. Discovery opens on September 1. Initial disclosures are due on October 1. Expert disclosures are due on January 29 on 2022. Discovery closes on February 28, 2022. Plaintiff's pretrial disclosures are due on April 14, 2022. This is dragging on and on. Plaintiff's 30-day trial period ends on May 29, 2022. Defendant's pretrial disclosures are due on June 13, 2022. Defendant's 30-day trial period ends on July 28, 2022. That's a whole year from now, and that's when the trial period will end for Ethan and for Antonio. And then plaintiff's rebuttal disclosures are due on August 12, 2022. 15-day rebuttal for plaintiff response period ends on September 11, 2022. Plaintiff's opening brief is due on November 10, 2022. And defendant's brief is due on December 10, 2022. Plaintiff's reply brief is due on December 25th, 2022. And then a request for an oral hearing, optional, would be due by January 4, 2023. Generally, the federal rules of evidence apply to board trials. Trial testimony is taken and introduced out of the presence of the board during the assigned testimony period. The parties may stipulate to a wide variety of matters, and many requirements relevant to the trial phase of board proceedings are set forth in Trademark Rules 2.121 and through 2.125. These include pretrial disclosures, matters and evidence, the manner and timing of taking testimony, and the procedures for submitting and serving testimony and other evidence, including affidavits, declarations, deposition transcripts, and stipulated evidence. Trial briefs shall be submitted in accordance with trademark rules. Oral argument at final hearing will be scheduled only upon the timely submission of a separate notice as allowed under Trademark 2, Rule 2.129A. So I'd say that this is definitely a victory for Ethan and for Antonio insofar as they didn't lose right away. That was a possibility because Preston in his filing was saying, let's go to judgment right away. Antonio doesn't have a lawyer. Well, in the interim, Antonio assigned the trademark to Ethan, and so Ethan owns the Comicsgate trademark right now, and he still owns it. And so there's a lot of proceedings that were coming up on his new application as well as Preston's applications, which have been suspended as a matter of law. They're not even considering those right now. And so here you can see that Preston's application for the trademark for Comicsgate was suspended on January 21, 2021, and that was while this matter was pending. So you're not going to consider his application there. It's possible that the same thing will happen to Ethan's application while this trial is ongoing. It's a live application, awaiting examination, has been accepted by the office, but has not yet been assigned to an examiner. So right now, as far as everything goes, the Comicsgate trademark that Antonio put forth supersedes all of these other applications, which are probably going to have to go by the wayside. I don't know if it's possible for Ethan to combine his current application and then say, this is how I've been using the mark, this is what I say the trademark is, versus the way Antonio had put it forth. And whether Scott Houtteman, who I had hired to produce the legal opinion that one and only one individual has obtained superior rights to the Comicsgate trademark, Ethan Van Sciver, back in earlier this year, while the matter for Critias was pending before the USPTO, I contacted Scott Houtteman as a way of trying to find a way to protect Comicsgate.org. I used the name Comicsgate. Critias looked like he was losing the trademark, and then looked like Preston might somehow get it away from Critias, and I was worried because Preston had threatened to take down Comicsgate.org last year, and I took that very, very seriously. So I said, all right, I probably need an attorney to protect the website. And so Scott produced this very thorough briefing on why Ethan, because he started using Comicsgate all the way back in 2018 to sell Cyberfrog and to sell super chats on his YouTube channel and on his YouTube show called Comicsgate Live. I think that, that this was the best argument to present to USPTO, which is that Ethan is the one who really owns the trademark. He has the common law trademark. He's claimed it since 2018, and that should supersede. He's the first to use it in commerce. All other claims, including Antonio, including Preston, including anyone who came afterwards. It's up to Ethan to say he owns the trademark, who's allowed to use the trademark. And so I'm okay with that. Ethan has been very kind and generous, I believe, with Comicsgate and bringing other people onto his channel to promote their projects as well. Comicsgate as a whole has raised millions of dollars in the past few years. Many people predicted that it was going to go away, that it was going to fail, and that it would not survive after a year or two. But Ethan is still raising hundreds of thousands of dollars. Check out his action figures campaign, just crossed $250,000. And he's still proudly calling himself Comicsgate, and he is now filed onto this claim and onto this motion to join a party and notice of appearance. As you can see from the trademark board, Ethan Van Sciver is now named as the defendant, and Antiel J. Malpica as well. Scott Houtteman is the attorney of record for the defendants. And so this is a victory, I think, for Ethan and for Scott. They, I think, did some timely responses here and brought Ethan onto this just in the nick of time so that this trial can go forward now. I think that, this is going to get very, very interesting, and this is going to be going on for a very, very long time. And that can't be good news for Preston, as the costs for the litigation will probably rise. And there's a lot that can happen in this trial. I mean, maybe, it's time to call it quits. It looks like Ethan has superior rights to this, that Ethan is the one who's going to win this in the end. So even if Antonio's mark is canceled because he improperly filed it, or Detective Dead was not fully fulfilled, or something like that, then the matter is going to come up to, all right, who registered next? Next in line would be Preston with his trademark applications. But I don't think that they're going to really withstand the test of time here. There's a lot of fraudulent, potentially, claims, according to Scott Houtteman, in his letter, that Preston was putting forth, including something Antonio argued in his answer, but was struck down, but that Preston had attempted to buy and purchase Detective Dead and the Comicsgate trademark from Critias before this proceeding even went forward. And then he claimed in his motion for the judgment that Critias had abandoned his mark, and it hadn't been abandoned, and Preston was recognizing Critias as the owner of the trademark because he tried to purchase it. And then he's pretending when he filed that he didn't know about Critias's mark. That's kind of, fallacious. It's fraudulent upon the board. So I don't think that Preston is really going to get very far with his own application, even if he manages to take away the mark that Antonio had filed for. Then as far as the certification mark goes, he can't have the certification mark and the registration for the regular mark, the standard mark. He can't have both. That's against the law. So the certification mark, you could just say goodbye to that one. He's not going to have a certification mark, even if he tried to, have this Renfamous with the, the sledgehammer and the mailbox thing going around and putting on other people's comic books. There ain't no certification mark that's going to withstand any scrutiny because he filed for it right after he went for the regular registration. And that was kind of dumb. So both of these have been suspended pending this trial that's going to be going on and on and on and on. So, we wish Ethan very well in this trial. Good luck. He got there, I think, in a nick of time to kind of drag out this proceeding, which is a victory because he continues to hold the trademark. He owns the trademark. He can continue doing business as Comicsgate. And Preston can't do business as Comicsgate right now. This is a live registration, even with the cancellation being pending right now. I don't see any avenue for success for Preston. And again, this is going to go on and on for a long time. We've come a long way since April 22, 2020. Preston Poulter trademarks Comicsgate, and they did this stupid video. Critias actually had filed for a motion to dismiss because Preston was claiming that he already had the trademark. And maybe Rich Johnston thought that he really had the trademark because it appeared in the database as an application, which hadn't even been examined yet. But here they were talking it up last year. Everyone was panicking, saying, oh my God, Critias lost the trademark. But then a lot happened since then. Critias revived his trademark. He managed to get Preston's application suspended. He got his own registration fully registered. And so I think Critias actually did a good job of keeping this away from Preston Poulter for as long as he did, and just in the nick of time to hand it off to Ethan, who is now assigned the subject mark in accordance, and the assignment has been filed with the USPTO for recording. And so because Ethan took up the mark, they're not going to go to, default judgment in one way or another on the trial. We're going to have a big, long trial, and it's basically starting over right now. And there's still time to answer. So Scott Houtteman right now, he's going to be preparing an answer to Preston Poulter on why Poulter's claims are basically fallacious. And this could end perhaps pretty quickly if Preston withdraws from this process. And so I guess we'll see what happens with the Comicsgate trademark. And that's the update. This is Robert Romano with Comicsgate.org. Hit that subscribe button, ring the bell for notifications, and have a good evening.